Chapter 13, Reimbursement and Subrogation, SS 192, Actual and Constructive Fraud. Security or reimbursement of purchaser. There is a plain and highly important distinction to be found in the authorities between actual and constructive fraud as affecting the question of repayment of the money actually advanced by a purchaser. If the transaction is fraudulent, in fact, it cannot stand even for the purpose of reimbursement or indemnity. While if it is only constructively fraudulent, it may be upheld in favor of the vendee to the extent of securing restitution of the amount of the actual consideration given or paid by him. And only the excess of the property will be subjected to the creditor's debt when the grantee purchases without actual notice of the fraud. But for a consideration which is so inadequate that it would be inequitable to allow the deed to stand as a conveyance, a court of equity may, upon appropriate allegations and proof, give it effect as a security for the consideration actually paid. And in cases of mere suspicious circumstances as to the adequacy of the consideration and fairness of the transaction, the court will not entirely annul the conveyance, but on the contrary will so frame its judgment as to protect the purchaser to the amount of the money advanced. Again, where strangers to the fraud paid off valid encumbrances upon the property, they are held entitled to be reimbursed and to be provided for in the decree before the complainant's claim is satisfied. The rule is laid down by Chancellor Kent in the great and leading case of Boyd v. Dunlap, that a deed, fraudulent in fact, will be declared absolutely void and not permitted to stand as a security for any reimbursement or indemnity. And this principle is upheld and followed in many cases. Thus in Shan v. Hanley, the vendee was not allowed to absorb the value of the premises in a claim for improvements made after constructive notice to her of the insecurity of her title and of the equitable lien of the creditor. In Briggs v. Merrill, Johnson, J. said, a party bargaining with a debtor with fraudulent intent does it at the peril of having that which he receives taken from him by the creditors of the debtor whom he is attempting to defraud, without having any remedy to recover what he parts with in carrying out the bargain. The learned judge adds, the law will leave him in the snare his own devices have laid. The court, in Stovall v. Farmers and Merchants Bank, said that there was no rule which gave a lien under a fraudulent contract. Every person who enters into a fraudulent scheme forfeits all right to protection at law or in equity. The law does not so far countenance fraudulent contracts as to protect the perpetrator to the extent of his investment. This would be holding out inducements to engage in schemes of fraud, as nothing could be lost by a failure to effectuate the entire plan. Judge Spencer said he presumed there was no instance to be met with of any reimbursement or indemnity afforded by a court of chancery to a particeps criminis in a case of positive fraud. And Judge Story remarked, in Bean v. Smith, I agree to the doctrine laid down by Chancellor Kent in Boyd v. Dunlap and Sands v. Codwise, that a deed fraudulent in fact is absolutely void and is not permitted to stand as a security for any purpose of reimbursement or indemnity. But it is otherwise with a deed obtained under suspicious or inequitable circumstances, or which is only constructively fraudulent. The loss of the amount paid by a fraudulent grantee is the penalty that the law inflicts for the fraudulent transaction. To refund to such a grantee the amount he has paid would be to destroy the penalty. It may be here observed that there seems to be authority for the proposition that loss resulting from depreciation may be apportioned between the debtor and the grantee, according to the sums respectively invested, when the conveyance is attacked by creditors. Thus in Schieffer v. Fithian, an insolvent purchased real estate for his wife, taking the title in her name, and advancing $2,460 of the consideration, the wife paying the balance of $4,000. The court ordered a sale of the property, and directed that 2,460 of the proceeds of sale be applied in payment of the complainant's debt. The court, after observing that they could see no error in this decree to the prejudice of the wife, said, she might well have been regarded as the sole owner of the property, and the quasi-debtor of her husband. As such, she would be bound to bear the whole loss arising from depreciation of the property. The court below seems, however, to have considered the husband's interest as a kind of resulting trust in the property, making him in equity a tenant in common. This was certainly the most favorable view in behalf of the wife that could have been taken of the case. It results in saddling the loss arising from depreciation pro rata upon both parties. The Supreme Court of Missouri say, in Allen v. Berry, that there is no principle of equity which allows a fraudulent grantee to offset against the value of the property the amount he may have paid for it. The fraud, observes Adams, J., renders the deeds absolutely void as to creditors, and the plaintiff, who was a creditor and as such became the purchaser, is entitled to recover the property and its rents, etc., as though no such fraudulent deeds ever had been made. Allowing the vendee to recover back the money would be in effect repaying him the amount which he expended in accomplishing the very thing which the law prohibits and condemns, as it was a wrong in him to obtain the title and the possession for a fraudulent purpose. It must be equally wrong to refund to him the price paid for it, $193, no reimbursement at law, while a court of equity, in setting aside a deed of a purchaser upon grounds other than those of positive fraud, annuls it upon terms and requires a return of the purchase money, or directs that the conveyance stand as a security for its repayment. This principle has no place as applied to an action at law. This constitutes one of the essential differences already discussed between relief in equity and the judgment extended by a court of law. The latter court, as we have said, can hold no middle course. The entire claim of each party must rest and be determined at law upon the single point as to the validity of the deed. But it is the ordinary case in the former court to decree that a deed not absolutely void, yet, under the circumstances, inequitable as between the parties, may be set aside upon terms. $194. Void in part, void in toto. We shall see presently that, as a general rule, a transaction void in part for any cause is entirely void. Russell v. Wynne is an illustration of our meaning. In that case, the question presented was whether a mortgage which was fraudulent against creditors as to a part of the property mortgaged could be upheld as to the residue. The court decided that as the mortgage was a single instrument given to secure one debt, to render it valid it must have been given in good faith, for the honest purpose of securing the debt, and without any intent to hinder or defraud creditors. Grover, J. Continuing, said, this cannot be true when the object, in part, or as to part of the property, is to defraud creditors. This unlawful design vitiates the entire instrument. The unlawful design of the parties cannot be confined to one particular parcel of the property. Entire honesty and good faith is necessary to render it valid. And whenever it indisputably appears that one object was to defraud creditors to any extent, the entire instrument is, in judgment of law, void. $195. Subrogation of purchaser to creditor's lien. The doctrine of subrogation is founded upon principles of equity and benevolence, and it may be decreed where no contract or privity of any kind exists between the parties. In Litterdale v. Robinson, Chief Justice Marshall said, where a person has paid money for which others were responsible, the equitable claim which such payment gives him on those who were so responsible shall be clothed with the legal garb with which the contract he has discharged was invested, and he shall be substituted, to every equitable intent and purpose, in the place of the creditor whose claim he has discharged. It may be noted that the party seeking subrogation must come into court with clean hands. This doctrine of subrogation is frequently invoked in cases where fraudulent conveyances are annulled. Thus, in Selleck v. Phelps, it was said that a person who acquired the title to property under circumstances which enabled the creditors of the vendor to avoid the sale, whether he be a purchaser or a voluntary grantee, would, after the payment of the claims of attaching creditors, be subrogated to their rights so as to enable him to hold the property against subsequent attachments, where goods were fraudulently conveyed but promptly seized by the creditors and sold by them. It was held that the fraudulent vendee should not be charged a greater sum than was realized upon the sale, and that he was entitled to a lien upon the proceeds of sale for the amount of a bona fide debt paid by the debtor out of the price given by the vendee. The right of subrogation was recognized in Cole v. Malcolm. It appeared that one Crawford conveyed real estate to his wife with intent to defraud creditors. Subsequently, his wife died intestate and her heirs assigned the property to the defendant. One of Crawford's creditors then entered a judgment against him and subsequently secured a decree setting aside the conveyance. The defendant then tendered the judgment creditor the amount due him and demanded an assignment of the judgment against Crawford. The court held that under such circumstances, upon payment of the judgment which he was obliged to satisfy in order to save his land from sale, the principles of justice and equity required that he should be subrogated to all the rights and securities of the judgment creditor, especially as the latter had, when his judgments were paid, secured everything to which he was entitled. So then, again, the tendency of the court to prevent a merger where injustice would result has been applied to cases of this character. Thus, in Crosby v. Taylor, it appeared that a grantee of land held it by a deed which was fraudulent as against the grantor's creditors. By a subsequent deed, the grantee secured from a prior mortgagee a deed of quitclaim of all the latter's interest in the premises containing this clause. which said mortgage is hereby cancelled and discharged. The court held that the deed constituted an assignment of the mortgage and did not operate by way of merger of it as against the grantor's creditors. A fraudulent vendee may create a valid lien upon the property in favor of a mortgagee in good faith.